This rulemaking hearing is called to order. My name is Anna Matlock. I serve as an Associate General Counsel in the Department of Commerce and Insurance Division of Regulatory Boards. I am here with Assistant Commissioner for Regulatory Boards, Alex Martin. Today is Monday, June 13th, 2022. This rulemaking hearing is taking place pursuant to Tennessee Code Annotated, Section 4-5-204, in Conference Room 1A of Davy Crockett Tower, 500 James Robertson Parkway, Nashville, Tennessee. The purpose of this rulemaking hearing is to solicit comments on new proposed rules to the established rules and regulations of the Division of Regulatory Boards General Provisions. The proposed rules permit equivalent credits towards requirements for occupational licensing credit to qualified honorably discharged veterans of the armed forces. The rule provides a process and acceptable documentation evidencing proof of eligibility along with the procedure for the appeal to the Commissioner should a denial of equivalent training towards licensure occur. A rule is defined as an agency statement of general applicability that implements or prescribes law or policy or describes the procedures or practice requirements of the agency. Proposed rules are filed with the Secretary of State. Notice is given to the public for comment, and a rulemaking hearing is held. Upon conclusion of the hearing and adoption of the proposed rules, the rules are forwarded to the Attorney General's office for review of legality. If approved, they are filed with the Secretary of State, which is responsible for publication, in the Government Operations Committee of the General Assembly. The rules must stay in the Secretary of State's office for 90 days, then end of which time will be the effective date. Those members of the public wishing to speak and appearing in person should place their name on the sign-in sheet to my right, located on the podium. Oral comments will only be accepted by those who have written their name on the sign-in sheet. Only those individuals will be permitted to speak. Is there anyone else that desires to offer oral comments that has not written their name on the sign-in sheet? Seeing that there are none, for those attending this hearing, I would call your attention to the table located at the back of the room. On this table, you will find red-line copies of the rule amendments addressed in today's rulemaking hearing. The notice of rulemaking hearings included the entire text of the proposed rules and were published on the Tennessee Administrative Register website on April 18, 2022. On April 19, 2022, an e-notify was sent to all individuals signed up to receive notifications for the department. I will now read the substance of the proposed rules into the record. Rule 0780-05-11-03, Military Training Equivalent Credit for Occupational Licensure, is a new rule. All subsequent references thereto are renumbered accordingly. 1. This rule is applicable to any state board, agency, or commission attached to the Division of Regulatory Boards, as listed in TCA Section 4-3-1304A, as used in this rule. A. The terms honorably discharged veteran, licensing authority, and member of the armed forces shall have the same meaning as set out in TCA Section 62-76-106. B. Commissioner means the Commissioner of the Tennessee Department of Commerce and Insurance or the Commissioner's designee. 2. A request for equivalent credit towards requirements for licensure based upon training received while serving in the armed forces pursuant to TCA Section 62-76-106 shall be made in writing on a form prescribed by the Commissioner at the time of the initial application. The request shall include A. The full name, address, and phone number of the applicant requesting equivalency. B. A certificate as evidence of training from the United States Department of Defense or United States Department of Veterans Affairs, which states the course name of training conducted and length of or credit given for such training. An acceptable certificate of training includes, but is not necessarily limited to, any certificate accepted by the United States Department of Veterans Affairs to establish military service found at https://www.cem.va.gov/HMM/discharge_documents.asp. A licensing authority may request additional documentation or information to reasonably determine the applicant's eligibility for the equivalent credit. C. A statement that the applicant acknowledges that the department may contact any agency to verify the applicant's military service and training certificate. D. A certification under penalty of perjury that the information contained in the request for equivalent training is true and accurate to the best of the applicant's knowledge. This certification shall not be required to be notarized. And E. Such other information as the licensing agency may reasonably request. 3. Upon receipt of a certificate of training, a licensing authority must determine whether such training is sufficient for equivalency and the amount of credit to be awarded to the applicant utilizing the following factors. A. Whether the applicant qualifies as a member of the armed forces or who is an honorably discharged veteran. B. Whether the training was conducted while the applicant was a member of the armed forces. C. Whether the certificate or documents submitted indicate the training provided equivalent hours or measure of time equivalent to the licensing authority's requirement for licensure. D. Whether the certificate or documents submitted indicate the training provided equivalent outcomes or objectives for licensure. E. Any other factor which the licensing authority determines is required to establish an equivalency between the training and the licensure requirement. 4. Upon determining if some or all of the training is equivalent and how much credit will be awarded to the applicant, the licensing authority shall notify the applicant of its determination. 5. Any appeal pursuant to TCA Section 62-76-106 by a person aggrieved by a decision of a licensing authority concerning the eligibility or whether the training meets the requirements for licensure must submit notice of the appeal to the licensing authority in the same manner as the initial licensure documents in the form prescribed pursuant to Tennessee Comprehensive Rules and Regulations 1360-04-01-.07. Review of the appeal will be conducted by the Commissioner or Commissioner's designee and must be conducted in the same manner as provided in TCA Section 4-5-322. Pursuant to TCA Section 4-5-322 B1A4, Requests for appeals shall be filed within 60 days after the entry of the licensing determination under paragraph 5 of this rule. The authority, TCA 62-76-106. As the agency hears public comment on the proposed rules, I, as moderator, reserve the right to limit such comments if they become repetitive. Please limit your comments accordingly. Before I take public comments, I will read comments that I have received via email prior to this hearing. To date, I have not received any comments via email for this hearing. There also are no names on today's sign-in sheet. As I have observed no comments, the comment period has concluded. Lastly, there are several measures I will need to adopt as required by TCA Section 4-5-222. First, the hearing language as amended will be adopted. Secondly, the Assistant Commissioner will adopt the Regulatory Flexibility Addendum / Economic Impact Statement. Pursuant to TCA Sections 4-5-401 through 4-5-404, prior to initiating the rule-making process, all agencies shall conduct a review of whether a proposed rule affects small business. The proposed rules do not affect small business directly. These rule amendments are specifically tailored for members of the military with occupational licensing experience that can be applied to Tennessee licensure. Therefore, the impact, if any, will be positive for small businesses and open opportunities to attract new customers. Should members of the armed forces or honorably discharged veterans take advantage of this opportunity? As these rules amendments make it easier for members of the armed forces, who are individuals that are often transitory, depending on their military assignments throughout the country, this rule amendment may help attract economic activity to Tennessee. Also, it may assist those honorably discharged veterans seeking new opportunities to use previously acquired skills to assist within the Tennessee workforce. The Department knows of no other less burdensome, less intrusive, or less costly alternative methods of achieving this purpose and the objectives of the proposed rules. The proposed amendments would require minimal, if any, costs for compliance. The Department is unaware of any similar rules and regulations in other jurisdictions. The Department does not foresee any impact to consumers with the promulgation of the proposed rule amendments. As these rules do not impact small businesses directly, an exemption for small businesses would not be beneficial. Next, the Assistant Commissioner will adopt the impact on local government statement pursuant to Section 4-5-228. The Department of Commerce and Insurance of regulatory boards foresees no impact on local governments. Lastly, I will adopt the answers to the additional information required by the Joint Government Operations Committee. All agencies, upon filing a rule, must submit the following pursuant to TCA Section 4-5-226 I-1. A brief summary of the rule and a description of all relevant changes in previous regulations effectuated by such rule. The proposed rules permit equivalent credit towards requirements for occupational licensing credit to qualified honorably discharged veterans or members of the armed forces. The rule provides a process and details what acceptable documentation is required to evidence proof of eligibility. The rule also provides the criteria for the division to use in determining whether an applicant meets the requirements to be awarded credit for completing training toward occupational licensure. Lastly, the drafted rule details a procedure and rights afforded to applicants for an appeal to the Commissioner in the case of denial. A citation to description of any federal law or regulation or any state law or regulation mandating promulgation of such rule or establishing guidelines relevant thereto. There are no known federal or state laws or regulations mandating promulgation. C. Identifications of persons, organizations, corporations, or governmental entities most directly affected by this rule, and whether those persons, organizations, corporations, or governmental entities urge adoption or rejection of this rule. The proposed rules would affect future honorably discharged veterans or members of the armed forces that apply for military equivalent credit for occupational licensing. The proponents of these rules likely include members of the military. The Department does not foresee a particular segment of opponents. D. Identification of any reporter or any judicial ruling that directly or the necessity to. There are no known additional known opinions of the Attorney General and reporter or any judicial rulings that directly relate to these rule amendments. E. An estimate of the probable increase or decrease in state and local government revenues and expenditures, if any, resulting from the promulgation of this rule, and assumptions and reasoning upon which the estimate is based. An agency shall not state that the fiscal impact is minimal if the fiscal impact is more than 2% of the agency's annual budget or $500,000, whichever is less. There is no foreseeable probable increase or decrease in state and local government revenues and expenditures resulting from the promulgation of these rule amendments. Sections F, G, H, request identification of appropriate agency representatives possessing knowledge of the rules that will explain the rules at the scheduled meetings for committees. Those individuals are going to be the Assistant Commissioner for Regulatory Boards, Alex Martin, as well as myself, Anna Matlock, Associate General Counsel for Division. Any additional information relevant to the rule proposed for continuation that the committee requests. There is no additional relevant information. That concludes the rulemaking hearing. Following this hearing, the rules will be put on Rulemaking Filing Form SS-7039, submitted to the Governor's Office for final review, and then submitted to the Attorney General's Office for review and approval. Once the Attorney General's Office signature is obtained, these are filed with the Secretary of State and generally become effective 90 days from date of filing after receiving a positive recommendation from the